The complaint in federal court must comply with the federal rules of civil procedure. It only has to have what we refer to as notice pleading. That means that the plaintiff has to just show the defendant and the court generally what the essential allegations are. It doesn't have to prove the entire case in the complaint. The entire case eventually has to be proven by a preponderance of evidence at trial, but the complaint just has to give sufficient notice to the defendants and the court of what the general allegation is. However, this complaint really was a complaint. It sounds like a stream of consciousness from a Kvetch Fest over at Viacom. Viacom was very upset that there was an awful lot of uploading of materials on YouTube, some of which is from copyrighted material. I got a copy, as I mentioned, of the complaint, rather lengthy, and paragraph 2 seems to have some rather interesting statements. YouTube has harnessed technology to willfully infringe copyrights on a huge scale, depriving writers, composers, and performers of the rewards they are owed for effort and innovation, reducing the incentives of America's creative industries and profiting from the illegal conduct of others as well. Okay? Using the leverage of the internet, YouTube appropriates the value of creative content on a massive scale for YouTube's benefit without payment of licenses. Well, it's probably true. YouTube's brazen disregard of the intellectual property laws fundamentally threatens not just plaintiffs, but the economic underpinnings of one of the most important sectors of the American economy. Well, maybe that means that if YouTube can continue doing what they are doing, the economy is going to go down the tubes. So we're going to go into a tailspin. In fact, it's a rather lengthy complaint. If anyone wants to read it, I'll be glad to email it to you. I got it from the attorney for Viacom. I Googled him and found out his location, so I asked him for it, and he emailed it to me. The next paragraph states some things that are, shall we say, food for thought. A vast amount of the content consists of infringing copies of plaintiffs' copyrighted works, including such popular television programming and motion pictures as SpongeBob SquarePants. Oh, my God. Are they going to let them get away with uploading a few minutes of that? The Daily Show with Jon Stewart. Good grief. The Colbert Report. South Park. Oh, if they can upload 5 minutes of South Park, the economy is going to go down. We're going to lose tens of thousands of jobs. Ren and Stimpy. Oh, we're going into a depression. MTV Unplugged. I want my MTV. An Inconvenient Truth. I printed this out, by the way, on recycled paper. I use less energy than Mr. Gore in his 20-acre estate. And Mean Girls. Good grief. 600 seconds of Mean Girls, and can you imagine what's going to happen to our economy? Well, you know, this is really not the type of situation, shall we say, that's kind of the one in Princeton University Press versus Michigan Documents. In Princeton University Press, the publishers were complaining that if Michigan Documents could copy scholarly works without any liability for copyright infringement, then anyone could copy any scholarly works. Anyone could copy any works and say, well, it's somewhat for educational purposes, and then sell it at perhaps a few cents on the dollar. Students would like that. They could buy their books real cheap, but then pretty soon the publishers would get out of the business of publishing. All of you economics majors know that capital will move to where it's used most efficiently. And if there was no copyright protection for scholarly works, then that could have an adverse effect. On the other hand, I ask you to assess, are we going to go from a recession into a depression if someone can upload 600 seconds of South Park on YouTube? How do we reconcile all of these issues? Are there any takeaway points that we could possibly look at and see if we can point to something that perhaps might give us some ideas, maybe some takeaway points, even if we can't resolve all the issues? Well, number one, literal copying of copyrightable subject matter is copyright infringement. We saw that if someone copies like 95 pages from from FDR, Black Politics, during the age of FDR, that's a scholarly work, or from Public Opinion. These are scholarly works, or if it's just a sequence of bits, ones and zeros in a computer program, that's literal infringement. Number two, fair use is a defense to copyright infringement. The factors are enumerated in the statute. There's a body of case law. I'm pretty sure the case law is going to expand dramatically based on this litigation. Number three, in general, the fair use defense is weaker if the defendant produces a work which detracts from the revenue stream or potential revenue stream of the copyright owner. And number four, the corollary of that is that, in general, the fair use defense is stronger if the defendant does not engage in any conduct which detracts from the revenue stream or potential revenue stream of the copyright owner. Well, these are the principles. So now I've told you the principles. I could stop here. But principles are just that. They're in a vacuum unless they're applied in the real world. What's the real world takeaway point? It's the money. Who has to pay who how much? Who gets to keep how much? Who owes who how much, and who is absolved from liability for how much? Google has made some Silicon Valley entrepreneurs rich, millionaires, billionaires. It's made Stanford very rich, almost as rich as Harvard. Well, maybe not that rich. There's a lot of money to be made in this. And in fact, other media companies have, in fact, stepped up, and perhaps they have made quite a bit of money also. Shortly after the litigation was instituted, there was quite a bit of media coverage of the litigation. And in fact, there was an article here in the Boston Globe. It was one of the numerous articles that was circulated. I printed out a copy. In the article, there was a reporting of the filing of the complaint, and then what does this really mean? The writer, the author of the article, says that other media companies, including CBS and NBC Universal, have previously signed deals licensing some content to be posted on YouTube. Some think that the Viacom lawsuit could be a precursor to a deal between Viacom, run by media magnate Sumner Redstone, and YouTube. So what is this about? Like most lawsuits, it'll probably be settled. Could be settled before trial, maybe settled after trial. Probably there'll be some exchange of money. Probably there'll be an agreement that some people can do some things, some cannot do certain things, some can upload a certain amount, some cannot upload a certain amount under certain circumstances. I have reason to suspect that Ren and Stimpy and South Park will be around no matter what. Well, they may not be around, but if they're not around, it's not because they've been uploaded on YouTube. Maybe it's because the popularity of the show has gone down. Sooner or later, there'll be some sort of resolution. Then one wonders, how will this affect us, the consumers? Will we still be able to go up on internet search engines? Will we still be able to find what we want to get? Will we have to look at a lot more ads before we get there? All I can tell you on that is stay tuned.